In this video, you're going to understand what healthcare fraud charges are and how you should defend healthcare fraud charges. Our firm, Chapman Law Group, has defended thousands of individuals who faced government investigations, licensing board complaints, and even federal indictments related to healthcare fraud, over-prescribing, and False Claims Act allegations. And, one thing remains true about every single one of those cases. An early investigation at the outset of the representation would have clarified the health professional's options very soon so that we can get clear direction on how to resolve the case in the best possible way. That's why it's important that you get in contact with an attorney that specializes in healthcare fraud as quickly as possible. At Chapman Law Group, we have a number of attorneys located in many states: California, Michigan, Florida, Tennessee. We have the ability to operate nationally and defend healthcare fraud cases across the country. I've personally tried cases in many states across the country and achieved victory for clients. One of the reasons why we're able to defend healthcare professionals so effectively is because of our professionalism and our knowledge. We spend most of our time dealing with healthcare fraud cases. We have individuals who are specialized in reviewing healthcare fraud cases, investigating them, and making sure you get the best defense possible. Personally, I have a master's degree from Loyola University in healthcare fraud, waste, and abuse. Specifically, that's in addition to my law degree. So I told you I'm going to teach you a little bit how to defend these cases, and I will certainly do that in the event that you choose us to represent you, or maybe you have a case where you're represented by somebody else. There's some things that you need to do in your defense to ensure that you have the best possible chance. The first thing, an early investigation. There's no such thing as a sleeping dog when we are talking about the Department of Justice. You have to act, and you have to act quickly to get information, interview witnesses, get documents, and review them. The second thing that we need to do, selection of counsel, and make sure that we have the right team, including experts, to be able to defend our case. Expert witnesses are sometimes hard to come across when you're at the other end of the Department of Justice, meaning you're facing off against them. There are many experts who simply won't work with a federal criminal defendant. We have a team of experts at the ready that we can put onto your case and help you out as quickly as possible. The third thing, pretrial motions practice. A motion is a request to the judge. You need to level the playing field. Imagine this is sort of shaping the battlefield for your case. You need to file motions related to your case to ensure that you have the best possible chance of a fair jury, the discovery that you need, and you have the ability to keep the government honest and within the bounds of the rules. Many people wishfully think that they will be able to get a pie-in-the-sky dismissal. I tell most of my clients that might happen for you. It has happened in cases of mine. But for the most part, you need to prepare yourself for trial, and you need to do it relatively quickly. Here's why. Many defendants hang out for years, kicking their case down the road, hoping it'll simply go away. That is the worst advice possible. As this indictment grinds you down over years and years and years, you will lose the will to fight. Defendants usually have the most will to fight within about 18 months. And if your counsel isn't getting ready for your day in court as quickly as possible to bring your case to trial as soon as possible, the chances of you getting an acquittal go down drastically, and your will to fight, your financial resources, and the will of your family to sustain such a long battle starts to go down. So early investigation, decisive action, and getting your case to court as quickly as possible is going to leave you with the best chance of success. And then finally we get to the trial. And here's where the magic happens. I've had a number of acquittals, like I told you, 150 counts of acquittal, and we've been involved in many, many more cases. Not everybody is lucky enough or good enough to get an acquittal. It's a difficult thing to get. But the things that you have to do to get an acquittal require a significant amount of background research and knowledge into the witnesses and case preparation. The magic doesn't just happen in the courtroom. It happens before the courtroom. But you need to deliver the case with a strong theme and theory showing innocence, and you need to keep your credibility alive for the jury. I've said it in my books, I've said it in podcasts, credibility wins cases. It's the most important thing for every single federal trial. Credibility is important. And in order to have credibility, you need to know the facts. And in order to know the facts, you have to do a better investigation than the Department of Justice. Thankfully, you may have access to the defendant's knowledge. Your knowledge of the case is very important. Knowledge of witnesses, maybe employees at a practice or patients. All of these people come together to create a picture of the case and a strong theme and theory. And in order to develop that theme and theory, you have to understand the case and you have to live it and breathe it. That's what we do with all of our cases. When this all comes together and you deliver the case at trial, you've got to fight all the way to the end. And it's a very stressful moment standing up and waiting for the jury to deliver that verdict, but I've heard it 150 times so far, the word's not guilty. And that's something that we hope we can deliver for you. But you've got to start early and you've got to be aggressive and you've got to move quickly in order to get an acquittal in a healthcare fraud case.